Thank you for having me. I'm here kind of on a discrete area, which is the arbitrator ethics standards that were adopted by the Judicial Council. Back in 2001, the legislature passed Code of Civil Procedure 1281.85, which directed the Judicial Council to adopt a set of ethics standards for neutral arbitrators in contractual arbitration. And the bill that put that forward was supported by the Judicial Council, by the governor, and by the Senate Judiciary Committee. And it was spawned by some of the same concerns that I think have been brought forth in these hearings. But at that particular time, arbitrators in contractual arbitration were not subject to any statewide comprehensive ethics standards. There were definitely requirements with regard to disclosure, but there weren't other ethics standards. So the legislature looked to the Judicial Council to work on this. It's not an area that we otherwise have any business in because it's outside the judicial system. But I think that the Judicial Council was selected, the Judiciary was selected to work on this because the Judiciary has a number of other sets of ethics standards for individuals who operate in a neutral capacity. The California Supreme Court adopts the Code of Judicial Ethics for judges. The Judicial Council had adopted rules of court for judicial arbitrators who work within the court system in a non-binding arbitration process, as well as standards for other types of neutrals such as referees. So this task was given to the Judicial Council, and in 2001, when the legislation passed, the Judicial Council set up a group of individuals to kind of counsel staff on this. They included law professors, arbitrators, individuals from the consumer protection area, and we worked for a number of months to develop a set of ethics standards. Since that, they were adopted initially effective adopted in April of 2002, effective July, and then they were immediately sent out for public comment again because it had been a pretty intense process of developing them, and they were amended in December of 2002. Then they were in place for about a little over 10 years. And in 2013, the Judicial Council again looked at them and adopted some changes. That's kind of the history of them. In developing those, the group looked at a number of things. They looked at the kind of framework of statutory provisions in California that already dealt with arbitrators, particularly existing obligations for disclosures and for disqualification of arbitrators. They looked at standards, voluntary standards of a number of different organizations, including AAA, the American Bar Association, had a set of standards that had been adopted by a number of groups. They looked at the standards for judicial arbitrators, as I mentioned, and they looked at the kind of legislative history of this provision and the goals that the legislature had in delegating this to the Judicial Council. So what did they adopt? I'm going to give just a short summary of the existing standards as they are in effect now. They cover the kind of overriding intent stated in the standards is to guide the conduct of arbitrators, to inform and protect participants in arbitration, and to promote public confidence in the arbitration process. And the kind of core focus of that is trying to ensure the neutrality of the arbitrator. The general duty stated in these standards is that an arbitrator must act in a manner that upholds the integrity and fairness of the arbitration process, and he or she must maintain impartiality toward all participants in the arbitration at all times. The standards then say that an arbitrator who cannot be neutral must decline to be appointed in a particular case. And then kind of the heart of the standards have to do with disclosure. So as I mentioned, at the time that these standards were adopted, there were already very extensive requirements in the Code of Civil Procedure that related to disclosure by arbitrators. So what the Judicial Council did was the delegation to the council said, you are permitted to expand on those, but not contract them. So we took that as the base and then added some things to that. So I'm going to go over what was added to that. So the standards require that arbitrators make supplemental disclosures regarding any matter that they become aware of after they take an appointment, after they make the initial disclosures. They expand the disclosures that are required when there's relationships or affiliations with family members to include domestic partners, and they have include some definitions of what is an immediate family and an extended family. They require arbitrators to disclose service as an arbitrator for a party or an attorney for a party, to disclose both services as a neutral selected by a party arbitrator and also as another kind of neutral, not just arbitration, but as a temporary judge, a mediator, or a referee. That was one of the specific requirements of the legislation. They require a summary of information. So if an arbitrator has had 5 or more cases with a party or an attorney for a party, they require a summary of that information. So hopefully it's a little bit easier to digest than that spreadsheet you were talking about. They require if a disclosure if the arbitrator or a member of his or her immediate family was an employee, expert witness, or a consultant for a party or a lawyer within the preceding 2 years. They require the arbitrator to disclose if he or she or a member of his immediate family has an interest that could be substantially affected by the outcome of the arbitration.
So rather than have you continue listing them, because I know they're available, let me just cut through. What is the enforcement mechanism if judges do not comply, or if the neutral doesn't? Yeah.
So the delegation to us did not give us the authority to enforce this. There was no body established to enforce these. So the enforcement mechanisms are embedded in the existing legislation related to arbitration, the California Arbitration Act. If an arbitrator fails to make a disclosure that is required under these standards or under the statute, then that's a grounds first for disqualification if the parties know that there was a failure to make a disclosure. And second, if they find that out later, it's a grounds for vacature of the arbitration award. I don't know if anybody talked about what vacature is, but essentially it's the overturning of the arbitrator's award.
Is there any sanction to the neutral for failure to disclose or comply with the provisions?
There is not.
Ah.
Okay, the existing law is all focused on whether that arbitrator gets to serve as an arbitrator and whether the decision made by that arbitrator, if it gets that far, stands.
Thank you. Thank you very much. And if there are any questions going forward, which I'm trying to get this done under the wire, and I think we're due out of here at 5 o'clock. So, Mr. Palevsky, the issue at hand is arbitrator ethics and issues relating to the appearance of bias or unfairness in arbitrations. And I think we've just hit upon potentially one of your subject matters, but I'll go ahead and let you proceed.
Okay, thank you. Forgive me if I talk fast. The ethics, first of all, it doesn't matter completely if someone is fair. What matters is the perception of fairness, whether you're a judge or an arbitration. And I don't think there's enough attention paid to the perception. Second, you develop ethics standards for the worst, not for the best. JAMS and AAA do have some minimum standards. I help them draft them. I can tell you, as a matter of fact, they don't always follow them. The best example is JAMS has a minimum standard that says you have to have the same rights and remedies you have in a court, or else we won't administer it, until the class action prohibition came along. And first I convinced them that they should say we're not going to handle the cases, and then when the corporate bar started writing them out of agreements, they said, sorry, we have to protect our business. So it's nice to have minimum standards. It would be much better if they enforced them. And when they do enforce them, the companies that want to overreach just simply go to other providers. The National Arbitration Forum is not permitted to do work in California or in Minnesota because of massive frauds and conflicts of interest that were not disclosed. So we have to set up we have to create some mechanism and ethical standards for providers. Many years ago, some folks who were really students of ADR at Georgetown University and CPR in New York spent 2 years with the president of AAA and JAMS authorities creating a set of ethical rules for provider organizations. As soon as they were created, the president of AAA asked to have their name taken off it. They said no. JAMS said, we'll follow them. To this day, there's not a single provider in this country who follows those ethical rules. The ethical standards that were created by the Judicial Council were actually very good, but there were some very big holes. And a lot of the changes that were made 2 years ago came about because I went to the Judicial Council and pointed out the holes, and the Chief Justice was good enough to appoint a committee to consider them. Let me identify those major holes to be very specific things you can do. The good rules say you have to disclose all past cases. You have to disclose all present cases, and you have to disclose any future arrangements for cases. You can't have ex parte contacts during the pendency of the arbitration, and during the pendency of the arbitration, you may not act as a lawyer, expert, or consultant for any of the parties. Those are all great rules. However, in the original rules, they inserted a provision that said, if you check a box on this multi-page form that says, I will take new cases, that you can take as many new cases from one side of the dispute as you want without even telling the other side, which means you can take hundreds of thousands of dollars worth of cases, 30, 40 cases, and have basically a secret side relationship with the arbitrator. So one of the things we went to the council and asked them to fix was that. So the new rule basically says if you check the box, they now have to disclose that they've taken this 30 or 40 new cases, but there's nothing you can do about it. So you're stuck in a system and you're being told that they're paying your arbitrator $30,000. And you say, well, what if you don't want to use an arbitrator who checks that box? Because many of them say, I would never do that. As a lawyer, I think it's unethical to offer new business to an arbitrator in my case. I would never do that. It is astounding to me that arbitrators think it's okay to take tens of thousands of dollars in business. So you say to JAMS, what do you do if you don't want an arbitrator? They go, well, choose someone who doesn't check that box, except that JAMS and ADR Services takes their disclosure forms and they allow the arbitrators to fill out every question except that. And they check it by default in bold print. So JAMS doesn't even allow their arbitrators to fill out their own ethical disclosure forms and make their own decision as to whether they will take as many cases as they want. As the rule was developed, it ended up saying the mere fact that you take another case in and of itself isn't enough to disqualify people. Fine. But we are seeing cases where they're taking literally, Mr. Welch is a good man, he's wrong, I've seen the documents, 30 new cases after the case was taken, 40 new cases. As I was walking into this hearing, Bernard Alexander, the former president of CELA, told me he took an arbitration with an arbitrator that he was recommended to, and since he took the case, they have disclosed 9 new cases with the same law firm. Now, you cannot maintain the perception of fairness if you allow arbitrators to take that many. It undermines every other one of those rules. So we need a rule that prohibits arbitrators without the consent of both parties from taking additional cases during the pendency of the arbitration. It's not something where the arbitrator can ask, because that's like asking somebody on a date during a performance review. They can only happen if the two lawyers themselves confer and agree in advance that it's okay. But otherwise, it undermines all of those provisions. Another big hole is the ethical rules say arbitrators must make these disclosures, and they must make disclosures on behalf of the provider. And if you don't like it, you can just bump the arbitrator. But there's no provision in the current rules to disqualify the entire firm. So for instance, if you want to use an arbitrator who won't take additional cases, you need to be able to disqualify the entire firm. If there's in the old days, my wife's a doctor. The medical malpractice insurance company created its own provider called the Patient Protective Association. There may be perceived to be a conflict there. If you want to disqualify a firm on the basis of the disclosures, that we've done 15,000 cases for Kaiser, there's no mechanism to do that. Third, you asked a great question about what is the sanction if someone violates their disclosure obligations. It's a great question, because aside from the fact that there is no mechanism for discipline, you've just paid $30,000 to an arbitrator and a firm and spent a year in arbitration, and now you got to do it again. There has to be some provision that if a decision is vacated because of your failure to disclose properly, you got to give back the money. That's an unjust enrichment. There needs to be some disincentive. There are absolutely no meaningful rules on marketing and solicitation. There used to be, for all time, the first ethical rule for arbitrators was that it's unethical to solicit cases for yourselves. You can make a general advertisement of your availability, but you can't be out soliciting cases for yourselves for obvious reasons. What the arbitrators did was they created an organization called the College of Commercial Arbitrators, and they created new ethical rules, and they eliminated that limitation on solicitation. Fortunately, I was able to be on the committee with Heather, and the Judicial Council put back in that you can't solicit cases for yourselves, but the marketing that goes on is really a problem. That arbitration providers are going up to corporations, they're going up to law firms, they're going to insurance companies, they're putting on seminars, they're making special arrangements, they are creating cash flows. I'll give you an example. There's cases on the books where a firm was paying JAMS $100,000, separate and apart from the administration of cases, for access to their computer system so they can keep track of their caseload. There's examples of insurance of people from providers going to insurance companies, going through their files and making recommendations that this case should go to ADR and you should use this judge. They're putting on seminars telling the lawyers in these law firms how to do better in arbitration and mediation, and then hearing cases from those people. There's no present requirement to disclose those marketing activities that create the appearance of bias. We have another problem. As you've heard, in an effort to keep the flow of arbitration cases going, even though the costs were so high, some courts have imposed the obligation on the employer or the company to pay the cost of the arbitration for consumers or employees. What's been happening on a regular basis is that when the company does not like the way the arbitration is going, whether it be as the award is about to be issued, is they stop paying. And the consumer and the employee is left having spent a year in arbitration, and the response from AAA and JAMS is, this is a business. No money, no award. That can't be. They have the ability to set their fees, to take deposits, and it is a cost of doing business. Adjudicating people's rights, whether you get this life-saving treatment or your career is lost, is an awesome responsibility. And if you're going to be in the business, then you must bear the burden of collection like every other business. It is unconscionable for a firm to say, you've arbitrated for a year, and until they pay me $21,000, you don't get an award. Can't be. And we need to do something to address that. So we need a recognition that the perception of fairness is essential. And unfortunately, you can't have a for-profit justice system. It is an oxymoron. In the old days, ADR was done by people who were dedicated to industrial peace and justice, it's sort of a nonprofit mindset. When JAMS was first created, it was created by Judge Knight, but it was funded by venture capitalists Warburg Pincus. There are nonprofits. For instance, an arbitrator who used to do labor management work would charge $100 an hour, and that same arbitrator in one of my sex harassment cases would charge $500 an hour, because they could, because there was no negotiation. For-profit justice does not work as a concept. And there is a solution. Aside from having ethical rules and giving the Judicial Council either the authority to develop rules for providers or for the legislature to do it yourselves. The simple free market solution to almost every concern you heard today is true voluntariness. I realize that your hands are tied to some degree, but the marketplace actually can ensure fairness if people are given a choice of whether to go or not. The marketing issue is a real problem because in the old days, you needed the consent of both parties. Now they don't. Now they can go to Blue Cross and say, write me into 7 million of your contracts. They don't need the consent of consumers or me, no matter how many times I might appear. They only have to market to the person who can write them into millions of agreements. It is a financial incentive that is corrupting the process. So everyone who loves arbitration and mediation and neutral evaluation and settlement should stand up and insist on ethics, that the perception of fairness be honored. We need ethical rules for providers because there is no regulation whatsoever. And it's not dams and AAA that we have to really worry about. It's everyone else who's creating their own arbitration systems.
Well, thank you very much. It's a rather interesting challenge. Of course, we do have certain limits. The federal, U.S. Supreme Court is...
Not as to ethics.
Well, that's true.
There's no preemption issue when it comes to setting ethical standards.
But the recognition that, we have a for-profit justice system with the allowance of these mandatory arbitration agreements. So it certainly is something that is food for thought, and agree that, perception really is critically important here.
Wouldn't it be nice to take some of those profits and funnel them back in to support the public court system? We can be creative.
Okay. I think slightly beyond the scope of this hearing, but certainly an interesting notion. Any other questions from the room? Okay, and we now have time for public comment. Does anyone wish to? We'll give you 60 seconds apiece to make a statement and respond, and thank you for your patience in being here, but if you give us 60 seconds, we'll make sure that is on, and if you tell us who you are and